Okay, welcome back, everyone, to our afternoon session on nascent competition in digital markets. My name is Stephanie Wilkinson. I am an attorney advisor in the FTC's Office of Policy Planning, and I will be moderating this next panel. So we just heard a really good discussion during the last panel regarding the analytical framework for evaluating acquisitions of nascent or potential competitors by established incumbent platforms in digital markets. We're now going to consider whether enforcement levels are appropriate for these types of acquisitions, which for the sake of brevity, I'm going to refer to as nascent acquisitions. And we'll start with brief opening remarks from each of our distinguished panelists and then continue with Q&A. So without further ado, I'm going to turn this over to Daniel Sokol. He's a law professor from the University of Florida, Levin College of Law, and a senior of counsel in the Washington, D.C.'s office of Wilson, Sonsini, Goodrich, and Rosati.
Thank you. Turns out I'm the only one with slides. Here's what I was thinking about, and it would have been helpful had I coordinated with the prior session because some of these themes have been covered, which means it's a successful session. And what I'll do is I will reposition the way that every either incumbent or new entrant has to when something interesting happens. So I thought my own framing of how to think about these markets was slightly different than other people's. It wasn't Paul's focusing on law. It wasn't some of the others focusing on economics. I thought about it in the following ways by giving two possible examples. One is where we have, what does nascent competition mean? One is where we have a nascent competitor. One is where we have a nascent market. So the nascent competitor is the Facebook, Instagram story, potential a new rival in social networking and or photo sharing, where the market in each of these was a little bit developed. The alternative was, I'd say, more Google ad mob, where the market itself was really, really new, so all the competitors were nascent, and it's not clear that this market would have actually succeeded. So even if the firms somehow were rivals, not clear to me that they were exactly, there's a lot less risk in this secondary type because it's not clear that the market is going to develop in the same way. So does the current legal framework for mergers work? Yes. And here the proof is peer review empirical studies. So actually this goes to another definitional question of what do we mean by tech? Because does tech specifically mean platform markets? That's where we've been focused. Or does tech mean broader technology related markets? So we heard, for example, Genzyme, Novozyme, fascinating case, and I think rightly decided. So that was in the pharma setting. So does tech also mean pharma? Does tech also mean devices? Does tech also mean hardware? Going to our very first panel today, does tech mean fintech in a way that's, say, different kind of mechanism? And here I want to thank Steve for walking through like how actually platforms are not all made the same. So these are some introductory thoughts. I'm going to zip right through these in interest of time. So venture capital actually is riskier. The law of venture capital, which I teach, is also riskier. And so we have various legal tools along those lines. And I give some examples for that of why that's the case. But you've heard already quite a bit of that. So I'm actually going to focus on something else. Two different things. One is the changing VC ecosystem. So again, if we're thinking that tech equals platform tech, then it's fascinating that up until now, what we haven't really heard about are, for example, 3 very large tech companies in China with a number of other large companies, if we're looking, for example, by market cap or by revenue. These are significant players as well, and they're also significant investors in the there's significant Chinese investment in the ecosystem. How do we know? Because this past quarter was the first time Chinese venture capital surpassed that of US venture capital. Yet this is not what we've had the conversation about as of yet at this hearing, so I raised that. The second is we've talked simply about venture capital. Let me suggest to you that there's this other category called corporate venture capital. So I think one of the, though this has existed for literally a long, long time, decades, Intel was really the first tech company, as I would define tech, to spend lots of resources in this area for corporate venture capital, billions over the course of years. The last year in the deal book, I think formal corporate venture capital was roughly some $30 billion. And the way that they're trying to make investments in corporate venture capital is much the same way that we're seeing in traditional venture capital, but somehow it might benefit the company in new and interesting ways. People forget after Peter Thiel invested in Facebook, you know who the next major one of the next major investor was? A little company venture capital company you've never heard of called Microsoft, okay? We see this kind of innovation in corporate venture capital, but based on what Will Tom said, I'm gonna throw in yet a third thing, not on the slide. This is how you know I'm repositioning. And that is, there's a lot of investment just short of actual financial investment. So think of any kind of strategic alliances, licensing agreements, joint ventures, et cetera, just short of actual merger type ownership integration, but something akin to a financial investment. So we'll zip through yet again. So I think I'm going to preview something that the next panel is going to talk about, and that is, for years I pushed commissioners on both sides of the aisle the importance of having a tech group. I have a different vision for what this might look like than what you've heard before. I think very clearly a tech group needs to be under the purview of the Bureau of Economics. There's a reason for this. Because it turns out, and this goes to something Bill Rogerson raised, and so I think it was masterful for a number of reasons, but I want to just quickly summarize some of the takeaways I got from his talk. It turns out that we learned by analogy, and we've seen certain things before, and we're applying it to new circumstances. I think that's just as true for law as it is for economics. But herein lies the issue, and this required integration of all the panels that we just heard. It turns out that what we have to understand is if law and antitrust law is based on economic analysis, the economic analysis is in turn based on how do we understand the technology. If you misunderstand the technology, our assumptions are wrong, and what we're looking for empirically is also wrong. This is why we put it in there. Second thing that I would do is I'd say, turns out all tech is different. So the person who understands devices doesn't understand online platforms. The third thing is we have a few different ways of seeing how this experimentations work. One is the Competition Markets Authority of the UK that's doing spectacularly interesting work in this area. The other is the President's Council Advisors on Science and Technology, where you actually bring in experts from the field from a while. Wouldn't that be awesome if we had very high-level experts coming into the Federal Trade Commission the way we do with the spectacular economists that spend 2 years from the academy? And I'll just end there. Thanks.
Okay, thank you, Danny. Next, we will hear from Diana Maas, who is the president of the American Antitrust Institute and adjunct faculty in the Department of Economics at the University of Colorado at Boulder.
Thank you, Stephanie, and thanks to the Commission for holding these hearings and to OPP for mustering the significant resources to plan and organize them, and especially to Stephanie and Elizabeth here for really doing a lot of prep work on this particular panel, which I think hopefully will show through in the discussion here today. So just for openers, I want to make three broad framing remarks. One is, we're here to talk about is the level of enforcement, antitrust enforcement involving digital markets and especially nascent acquisitions of nascent competitors adequate? Or should it be higher? Should it be lower? What should it be? So my observation is that history tells us that the levels of enforcement, this type of enforcement, is pretty low, actually. So AAI collects data on enforcement levels across long spans of time. We just filed a letter on the Smarter Act and included data in there showing about a 2.5% challenge rate across both agencies from about 2000 to present day, okay? So if you look at the number of acquisitions in the digital market spaces, over the last 3 decades, we're looking at, these are major acquisitions, rough cut numbers, do not cite or quote, but we're looking at upwards of almost 700 transactions. And I would query everybody in the room here, go back through your mental Rolodexes and ask yourself which acquisitions have been challenged by the FTC or the DOJ. And the list is very short. Okay, that doesn't mean that enforcement is too low or too high. It means that it's a question. It raises a legitimate question. So it's not because the agencies aren't looking or seeking and finding or not finding potential violations of Section 7. It could be because the agencies aren't using the right lens. And that would be my argument, that it's a lens problem. We're not asking the right types of questions. We're not looking at stepping through the merger guidelines methodology in a way that would be conducive to properly identifying and framing potential competitive harms in digital markets. So I think there's a lot to be learned there. So second, I want to try in my comments today to dispel some myths and arguments that have sort of driven, for lack of a better term, forbearance from enforcement in the digital market spaces. One argument is, well, we just don't have the tools. The toolkit isn't adequate enough. It doesn't have the right. Antitrust is too slow for the digital markets. It can't keep up. These were all arguments made in Microsoft, which turned out to be absolutely, patently false. Antitrust absolutely could take on the challenges presented by Microsoft many, many years ago, and it can do the same today. So it's not a tools issue by a long shot. Second is, well, it's difficult to predict what these nascent technologies are going to be doing. How are they going to develop? Are they going to turn into significant competitive threats? The failure rates are high. What do we do? Do we throw our hands up and say, hands off? We're not going to get involved here, or do we actually try and dig down and develop a set of tools and frameworks to help us enforce Section 7 in a coherent way? Third, in terms of dispelling myths and our arguments, is this argument that, well, if we lean on the digital markets acquisitions too hard, we're going to kill the goose that laid the golden egg. And that's this model of entrepreneurship that is financed by venture capital that creates small startups that are incubated by the platforms and that are taken into the fold by the platforms, which creates this sort of symbiotic or even other type of model. My response to that is we should not be waylaid by those arguments. Antitrust is not about picking winners and losers. It should be neutral to the type of business models that underlie a lot of innovation and how entrepreneurship spurs innovation. Entrepreneurship is about people, it's about places, and it's about process. There are lots of models of entrepreneurship, and antitrust should not be deferring to or favoring any particular model of entrepreneurship. Finally, I believe the current tools that we have in our toolkit, and I think this has been spoken to, are certainly adequate and flexible enough. We've got models, we have theories of competitive harm, we have many observations about conduct involving firms in markets with very high levels of concentration. But what we need to do is use the consumer welfare standard to the full extent of its capabilities. And that would be what I call a dynamic consumer welfare standard. That means we look at dynamic effects on the competitive effects side. That means looking at short-term price effects, but also longer-term dynamic effects around quality, variety, innovation, even choice, consumer choice. But we also look at dynamic effects on the efficiency side. Right now, arguably, and I'm sure many of you will disagree with me, antitrust has really suffered greatly from looking at very static effects on the competitive effects side, but then allowing very dynamic efficiencies as justifications for acquisitions. That's a very asymmetric, unbalanced implementation of the consumer welfare standard. We should be looking at a dynamic, symmetric implementation of the consumer welfare standard in this particular space. I'll leave it at that.
Okay. Thank you, Diana. Next, we will hear from Youn, Associate Professor of Law and Director of Economic Education at the Global Antitrust Institute. Prior to joining GAI, John served in various roles at the FTC's Bureau of Economics.
Thank you, Stephanie. Thank you, the FTC, for having me. It's exciting to be part of this panel. So I'm going to make you really happy, Stephanie. I'm going to talk about 1 minute, and then let's just get started with the questions and get this thing rolling. Basically, when we're talking about nascent competitors or technologies and potential competition, we're in a dynamic setting. And I think that's where a good place to be. Static is important, but dynamic clearly is harder. But it doesn't mean that it's not important. In fact, it's probably more important. And I think that holds for efficiencies and entries as well. So the point I think I would like to make, and it's something that Diane just mentioned, is symmetry. And I think there should be symmetry in how we approach both dynamic harms as well as dynamic benefits, static harms and static benefits. And I think that's the approach that we should have. Clearly, elimination of competition, whether static or dynamic, is important and relevant, and we have to look at it. But so are the efficiencies and entries. And I think that's the story that we need to be sort of focusing on rather than just on one side or the other, I think, to be fair. So what guides us, and ultimately it will be the evidence of each particular case. We like to generalize broadly what we learned or didn't learn from certain cases, but each case is going to be different when you're in the dirty business of bringing a case and analyzing a case. And I think that's sort of another takeaway I'd like to sort of establish. So with that, I'll conclude my comments.
Okay. Thank you, John. Next, we'll hear from Jonathan Kanter, a partner at Paul, Weiss, Rifkin, Wharton, and Garrison. Prior to entering private practice, Jonathan served in the FTC's Bureau of Competition.
Great, thanks, and it's an honor to be here alongside my fellow panelists and here at the Commission. I first stepped foot in the halls of the FTC as a summer intern in 1996 after my first year of law school, and at the time, the chairman of the FTC was Chairman Bob Pitofsky. He was revered then inside the building, outside the building, and everywhere he went. Seldom would you encounter a finer antitrust mind and a finer leader in the antitrust bar. He was a model of rigor, sophistication, and intellectual capability. And in thinking about this session and the hearings generally, I'm drawn to some of Chairman Pitofsky's writings, and if you indulge me, I'm going to read from them because I think it's a helpful backdrop, not just for this panel, but for the hearings generally. Chairman Pitofsky, who I think no one would argue was seen sipping locally roasted cold brew in Brooklyn while listening to 180-gram vinyl, taking care of his pet rooster. I think he was a very serious and rigorous antitrust practitioner. It is bad history, bad policy, and bad law to exclude certain political values in interpreting the antitrust laws. By political values, I mean, first, a fear that excessive concentration of economic power will breed anti-democratic political pressures, and second, a desire to enhance individual and business freedom by reducing the range within which private discretion by a few in the economic sphere controls the welfare of all. A third and overriding political concern is that if the free market sector of the economy is allowed to develop under antitrust rules that are blind to all but economic concerns, the likely result will be an economy so dominated by a few corporate giants that it will be impossible for the state not to play a more intrusive role in economic affairs. Chairman Pitofsky then discusses some of the inevitable criticisms and goes on to say, I quote, "Despite the inconvenience, lack of predictability, and general mess introduced into the economist's allegedly cohesive and tidy world of exclusively microeconomic analysis, an antitrust policy that failed to take political concerns into account would be unresponsive to the will of Congress, out of touch with the rough political consensus that has supported antitrust enforcement for almost a century." So against that backdrop, we're talking about nascent competition, dynamic competition. And one of the questions that often comes up is, well, how do we take the tools? How do we take the merger guidelines? How do we take all these things that we've come so familiar with and use as crutches to try to understand these issues in a dynamic space? And the answer really is not trying to fit the facts into a model and not trying to fit the realities of the market into a box, but if the boxes don't fit, then we need new ones. Or they weren't the right ones in the first place. And so I do think with that having been said, there are some helpful guideposts that we can use when thinking about nascent competition, both from a Section 2 perspective as well as a Section 7 perspective. So first is the Microsoft case still provides a very helpful framework for understanding the impact of nascent competition. It talked about exclusion of a nascent competitor. It's interesting to note that in the Microsoft case, the court said when you excluded a nascent competitor, you had to own what the acts of your own deeds and or the results of your own actions. And if you break it, you buy it. And so you didn't have to prove in that case that the nascent competitive threat would have resulted in something that came to fruition, but that it could have. And so in thinking about that, there are a couple of things that I guess I would encourage the Commission to think about and the Bar to think about. First, when should there be heightened concerns? I think Chairman Simons noted rightly that often if you're looking at market power, you look at the biggest companies. Well, bigger is more suspicious. And I don't think it's controversial to suggest that you're likely to see more problems when you have companies with market power and large market share. Winner-take-all or winner-take-most markets are likely to be more concerned for nascent competition that could be disruptive. Monopoly maintenance, acquisitions that can tend to create a monopoly or maintain a monopoly are the kinds of things that should result in heightened concern. Impact on dynamic competition. Markets where there's social utility, news, or information. These markets have traditionally, and the law has traditionally looked on them with greater scrutiny and greater concern because of the social value, and we should not lose that again, and that fits well with Chairman Petoskey's remarks. The behavioral realities of participants on the platform. So let's not try to pretend that consumers are homogeneous. They're idiosyncratic and often behave in unpredictable and sometimes quote-unquote irrational ways. Last thing is, does the transaction or the conduct relate to a conflict of interest? And will the transaction or the conduct change the incentive and ability to engage in that or exercise conduct as a result of that conflict of interest in a way that harms the integrity and the output on the platform itself?
Okay, thank you, Jonathan. And finally, we will hear from Sally Hubbard, a senior editor with the Capital Forum, where she covers monopolization issues and data regulation in high technology markets. Previously, Sally served as an assistant attorney general in the New York State Attorney General's Antitrust Bureau.
Thank you to the FTC for having me here today, and I want to give the standard disclaimer that I am sharing my own views and not the views of my employer. I want to echo actually a lot of what Jonathan just shared. Since this panel is about enforcement levels, I can really sympathize with enforcers since I was an assistant attorney general. The litigation realities for challenging these types of mergers are pretty harsh. And my view is that current antitrust doctrine is really missing the forest for the trees. And I don't think this is an accident. I think it's a result of a decades-long campaign by Chicago School economics and corporate defendants to really weaken the antitrust laws. So this is the reality that enforcers are facing. And in recent years, though, however, I've been able to step back from those harsh litigation realities as a writer, focusing exclusively on Google, Apple, Facebook, Amazon, and antitrust. And what I've gotten to do is have the luxury of looking at the big picture. I get to look at the forest. And what I'm seeing is really more like a cleared Amazon rainforest than a healthy competitive landscape. As Diana mentioned, there's been hundreds of acquisitions by the big tech platforms. I'm talking about Google, Apple, Facebook, Amazon. Hundreds of acquisitions, billions of dollars worth of deals. And many of those deals have allowed these firms to maintain their monopoly power, extend their monopoly power, or eliminate competitive threats. So when enforcers are looking at tech platform acquisitions, they shouldn't get distracted by promises of short-term consumer welfare enhancements, because what benefits consumers is competition. A short-term product improvement that's labeled pro-competitive does not justify the elimination of a competitive threat. After all, Section 7 of the Clayton Act prohibits mergers and acquisitions where the effect may be substantially to lessen competition or to tend to create a monopoly. The Clayton Act doesn't qualify this prohibition by saying, unless the merger creates efficiencies, or unless the merger leads to low prices in the near term, or unless the merger allows an entrepreneur to exit competition. And let's not forget the second part of Section 7. It prohibits acquisitions where the effect may be to tend to create a monopoly. This means, as others have pointed out, that enforcers should scrutinize acquisitions by dominant platforms more heavily than acquisitions by firms that lack market power. And as we've heard on some of these panels, our familiar metrics that we like to rely on as antitrust enforcers are not really that reliable, right? Prices, market shares, market definitions. Markets are very fluid. Those handy tools that we're so used to relying on can fail us when we're looking at acquisitions of tech platforms. But I want to remind everyone that price effects are merely one of the several metrics that are used to assess whether competition may be lessened. And low prices are not the goal in and of themselves. Competition is the goal. Competition is what maximizes consumer welfare in the long term. And the product definition markets can lead enforcers astray because the biggest competitive threats to platform incumbents are likely to come from firms that are in seemingly different product markets altogether. Why is that? Well, because startups that want to challenge tech giants in their core competencies can't actually get funded. So if our typical proxies aren't much help, enforcers should be able to show competitive effects directly. They shouldn't have to prove the second best proxies. And this is what the horizontal merger guidelines already say. But often courts don't go along with this. So where do we go from here? I see about 4 main options for enforcers. The first is to bring hard cases and try to change the legal doctrine and the current standards. You gotta pick the ones that have the best facts, but you also have to know there's a good chance you're gonna lose. And if Congress agrees with you and disagrees with the courts, that could help spur option number 2, which is a legislative fix. There's been some proposals like the Klobuchar bill. The odds of any of these things passing is a question, especially as these tech giants keep increasing their lobbying budgets. The third option is for the FTC to get creative with the tools that are available. Use Section 5, use a rulemaking authority as Commissioner Rohit Chopra has recommended. Know that privacy regulations can also open up competition, as can interoperability. And even make second requests automatic when you're dealing with such dominant platforms. Now, the last option is not really an option in my book, but that is to do nothing and allow tech platforms to eliminate competitive threats into perpetuity. Thank you.
Okay. Thank you, everyone, for these opening remarks. We'll now move into the Q&A portion of the panel. As a reminder to the audience, if you have questions that you'd like to submit to the panel, please fill out one of these cards. We will have people walking around the auditorium and collecting these cards, and then they'll make sure that they get sent up to me. Okay. So I'd like to start off the panel by asking everyone some broad foundational questions. Are current levels of merger enforcement in digital markets appropriate? Should the antitrust agencies be more concerned about false positives or false negatives when making enforcement decisions regarding nascent acquisitions in digital markets? And are there particular cases where you believe the antitrust agencies either went too far or did not go far enough in their enforcement efforts? And for such cases, I would be interested in hearing feedback that could be instructive for future investigations, such as whether there is an alternative analytical framework that you believe the agencies should have used to evaluate these acquisitions, or whether there are facts that the agencies may have missed that were reasonably available at the time of the acquisition, and if known, might have resulted in a different outcome. I'll open that up to the panel.
Can we volunteer?
Sure. Diana,
Okay,
you first.
thank you. So, very, very good question. I have just a couple of remarks on this. One is, frankly, it's difficult to say whether we should be concerned about false positives or false negatives for 2 reasons. One is we've had relatively little enforcement in the digital market spaces, so when you don't have any observations to work with, then it's kind of hard to tee up those counterfactuals. Second, we don't have the benefit, as we do in non-digital markets, of a lot of merger retrospectives. So we've now heard all day long how valuable merger retrospectives are. And of course, we're dealing with a lot of data and evidence, mainly through the work of John Quokka and all the scholars who have produced individual retrospectives, that really support the notion that we shouldn't be so concerned about false positives, that 4 to 3 mergers, for example, are almost incredibly surely to be damaging, and that enforcement actually supports higher levels of challenges in cases of 43 mergers. We're just not there. We have we're in a warp. We're in a time warp here because enforcement in digital markets has not, is really just evolving at this point, and we haven't done retrospectives. And we can talk about later what those retrospectives might look like. My second point on this particular question is, is the framework correct? Is the enforcement level correct? Well, I think the way you think about the framework is in the digital market spaces, much like in non-digital market spaces, you're talking about three fundamental types of consolidation. One is horizontal mergers. For example, Google Softcard, Facebook, Instagram. You're talking about vertical mergers that combine firms in adjacent markets. That would be Google ITA, that was online travel and back-end travel software. Apple Shazam, that was music identification technology and music digital procurement technology. But we're also talking about conglomerate mergers in the digital market spaces. I think this is the big one. It's that antitrust has never done well with conglomerate mergers. It barely does very well with vertical mergers. Cite CVS Aetna and look at our press release on the AAI website. Horizontal mergers, it does pretty well. Looking at overlaps and the elimination of head-to-head competition, we have lots of tools to help that analysis along. But it really sort of deteriorates from there. Vertical is a challenge. If vertical is a challenge, conglomerate is going to be an enormous challenge. So mergers like Microsoft, LinkedIn, I would put in the conglomerate merger space. You can argue with me on that. Facebook, Face.com, that was social networking and facial recognition. Google DoubleClick combined ad serving through pay-to-click and ad serving through banner and exchange ads. These are all mergers that that occur in more broadly defined markets. And that is very much in keeping with the digital platforms because it's all about linked services and products, connectivity, and the development of value-added services to users and consumers. Antitrust doesn't think well that way. It's all about transactions. It's all about buyers and sellers and suppliers and distributors. So we really do need a different frame of reference. And when we get to the conglomerate mergers and talks more specifically about competitive effects, I think we have even more problems there.
Can I weigh in?
John?
I've heard a lot about retrospectives, and I agree. You gotta be for retrospectives. If you're not for retrospectives, something's wrong with you, I guess. And so I'm for it. But if you're actually going to do it, how do we do it, and what does it look like? So let's get in our time machine, our Back to the Future time flux capacitor, or hot tub time machine, whatever you want to get in, and go back to April 9, 2012, when Facebook bought Instagram. Instagram at that time had 50 million people. What would we expect for that to be ex ante, looking ex ante to be exposed to sort of a okay merger? That Instagram would have puttered along to what it was, 50, grown at its historic rate, integrated into Facebook to some degree, and we're like, okay, that was a good merger. Didn't seem like it was that important a product. Or they discontinue it after a few years, Google Plus style, and it's just like, oh, it didn't really go anywhere. I guess it wasn't important again. Or just or it gets very successful. It becomes 1 billion users, or 19 times its size, which is the reality today. So when I look at that growth from 50 million to 1 billion, in a pretty short period of time, I don't know what to do with that. That doesn't strike me as on its face anti-competitive. It seems like it expanded tremendously and reached a lot of consumers. I don't know at first act, so I'm not going to assert it, but I'm sure Facebook has poured plenty of technology into that product. And so that's, I think, the difficulties we face with these counterfactuals and what is the right one for these types of things. And, suppose that Facebook's purchase of Instagram increased its probability of success. Let's just assume that. Whereas it was 50% times 3, which is a compound percentage of 12.5% of success in a market. There's a lot of hurdles these younger firms have to overcome, and there's some probability they fail and probability they succeed. What if they increased it, 20%, 30%, 40%? That compound probability doubles, triples. And so is that an efficiency we recognize? Would that, in a retrospective, be something we credit the agencies for getting right? And those are just the questions I have, and I'm not asserting Facebook, Instagram is the model of a pro-competitive potential acquisition or it's anti-competitive. It's just I think there's some difficulties in really coming up with the right counterfactuals when there's been exponential growth. And so that's sort of something I wanted to throw out there.
So the Facebook-Instagram merger is one of the ones that I think is kind of the biggest mistakes to have let through. And one of the warning signs that there was, that could have been a little bit of a red flag to look out for in the future, is that Facebook was paying $1 billion for Instagram at that point. Instagram had no revenue, and they had 50 million users. What did Facebook see? It was worth $1 billion to them. So that's a red flag to look out for. And then what has been the impact of this going forward? I have written about how I think a lot of the fake news and privacy problems that we're having with Facebook right now are related to the fact that it's a monopoly. It doesn't have the pressures of competition to discipline it. I think competition in the economy keeps firms on their best behavior, or either that or regulation, right? I prefer competition. I know after the Cambridge Analytica scandal, a lot of my friends said, oh, well, I'm quitting Facebook, but I'm still on Instagram. They didn't even realize that, they didn't have a choice. They didn't have a way to vote with their feet and say, no, it's not okay for you to give our data away without our permission. So I think, and another thing is that Facebook basically has Instagram as this fallback plan B. It's really behaving in an irrational way, letting its brand reputation go so downhill with the way it's really not fixing the problems. But it knows it has a plan B, which is Instagram. So I think that's actually one of the most problematic of the mergers, but I think pointing to that offer price is one thing to look at there.
Okay, Jonathan?
Yeah, so all helpful points. I'm going to stay away from commenting on any specific transaction or specific company, but I do think it's helpful to make a few observations here. One is, we seem to understand, or at least we feel like we kind of understand these issues in the context of Section 2, right? And so if excluding a company, it would be a problem, then, maybe buying a company is a problem. Maybe it's not, but is the analysis when you're talking about nascent competition really all that different? And should it be different? Maybe not. I think that's something worth considering. The second is, this kind of goes back to something that Danny was talking about, which is, and some degree Diana, I think we get tied up in formalistic distinctions like horizontal and vertical and conglomerate, right? I mean, it's like trying to watch 4K TV through an 11-inch black and white TV set, right? I mean, those are distinctions that really don't apply to a multidimensional, three-dimensional age. And I think sometimes the problem with the law focusing so much on economic theory is it gets anchored in theories that are kind of staid. And those kinds of distinctions as being the anchors for how we evaluate these kinds of problems tend to throw us off and away from the issues that really matter. And so I think we have to figure out better ways to look at the dynamic nature of competition. And when I think about it, people often talk about Schumpeter, and so long as, the next thing's on the horizon, everything's going to be fine. But the issue on platforms is that the next thing on the horizon is often this new nascent threat that comes on the platform. And so you have to make sure that there's enough room on the platform for these new threats to emerge and to breathe. And I'm sympathetic to what John was saying. I mean, these are hard issues, right? How do you figure out which deals to block and which ones not to block, when to take action and when not to? And I get that. It's hard. But I think the paralysis due to concern about false positives has resulted in perhaps an overcompensation to the point where maybe we're not addressing problems that need to get addressed because we're so dependent on defending our tools that we're not spending enough time rethinking them.
Okay, thank you. Danny?
Some very quick points. So sometimes we have merger retrospectives. We call them academic empirical work. The problem is a lot of times we only look narrowly at the IO economics literature. There aren't as many of these studies as we'd like, but in fact they do exist in finance, in information systems, in marketing, strategic management, and operations management. And specifically to the point of Facebook, Instagram, we have that. It's called an A publication to get you tenure at any of the schools where we had business school professors earlier. Steve, Judy, Robin, Bill. That was in management science. Lee and Agarwal's 2017 paper, Platform Integration, Demand Spillovers in Complementary Markets, Evidence from Facebook's Integration of Instagram. And in fact, what they find is that the deal was pro-competitive, and it actually also helped the larger of the third-party complementary app developers. So I think we can put that one to rest. Broadly, I'd say merger retrospectives are helpful in a different way. It helps frame a broader political debate, something John raised earlier. So I think one problem that the agencies have had here relative to other, this is the first time I've ever been told I need to speak into a microphone. Normally my voice carries. So the other thing is, relative to, say, DG competition, I think the US agencies do a less good job in this particular area, and that's in mergers. In deals that they allow to go through, they don't give the kind of detailed commentary, particularly for high-profile deals, particularly for platform deals that we've seen DG Comp do. And I think that this goes to some of the political questions that, that get asked, because people are frustrated because the agency simply isn't sharing its knowledge, I think, as effectively as it could. It's a different form of storytelling, but I think one that's highly important. The other thing is I want to put in a plug for the work of AI, because AI really has tried to think interdisciplinary-wise along a number of different areas to sort of think, what do we know, and how can we sort of bring in tools from different disciplines to help tell a more nuanced story. So plug there, but actually plug back to something that John brought up earlier, like how do we think, for example, about quality. So I want to plug somebody in the audience, and that's Debbie Feinstein, because when she was head of BC, one of the most fascinating, nuanced, and I think compelling speeches that she gave was to talk about how do we look at quality and how do we listen to particular stories, specifically in the hospital merger context for qualitative evidence, where, again, qualitative evidence doesn't get treated the same way in courts as the cost-based evidence does. And I think she gave a very nice framework for how the agency should use that. So final plug, thanks.
Great, thank you. Okay, so let's now move on to questions regarding product market, because we've heard a lot about this over the last few days with respect to platform markets. How should relevant antitrust markets be defined when evaluating nascent acquisitions? Would defining markets more broadly allow the agencies to challenge more of these acquisitions? And as you're answering that, think about, on the other hand, if markets are defined more broadly, don't we also have to consider how that will impact market structure and our ability to allege that competition is substantially lessened? In other words, if we define the market more broadly and we have to include more firms in the market, such that the market shares and HHIs become more diluted, would that actually reduce our ability to challenge some of these nascent acquisitions? Also, how would this impact our ability to allege a narrow product market in subsequent cases, if appropriate? John?
Yeah. So taking a step back, I know Paul Dennis went through the classification of what is nascent and potential competition. So I don't want, well, I will rehash a little of that, but I do want to just get some terminology clear, because I think it helps us answer this question. If done right, I don't think we go anywhere in terms of broadening or narrowing. So here we go. A nascent competitive threat came out of Microsoft largely as we sort of talk about it today, and it was about emerging technologies. In that case, it was Netscape and Java and middleware, as those being sort of technologies that were not in the relevant product market per se, but either would be in the future or would facilitate others, including themselves, in the future. And that was sort of the idea. And sort of on its face, that's a reasonable enough conjecture and hypothesis, and I think that's a good way of looking at it. Potential competition is, I like to think of it versus actual versus potential entry. Actual entry, we know, it's a competitor today and it's competing and affects price. Potential competition, as I perceive it, I know others use it a bit differently, but I think generally, as the guidelines, this is in sentence 1 of the merger guidelines, we hear a lot, oh, we need more stuff happening in FTC. And sentence 1, guidelines, outline the principal analytical techniques, practices, and enforcement policy of the DOJ FTC with respect to mergers and acquisitions involving actual or potential competitors. So there, the relevant market is the relevant market. It's just they're not in today, but there's some projection, whether it's tomorrow or 2 years or 3 years, that they will be in the future. Now, within potential competitions, there's further delineations. What is it? It's actual potential competition, and that's how I would think of it as just an entrant that hasn't come in yet but could. Then there's the perceived potential competition, where there's not really an entry story, it's just their presence constrains prices today, so they're a competitive influence. And then there's potential competition, which is the Nielsen arbitron, which I like to think of as a potential entrant in a potential market. I think that maybe is a little helpful, or future market. I think that's a little more fun, future. So just those are the terminologies. So if we do those right, I don't really think we need to go in broader stuff, because when we go broad, I think others have probably picked up on this, we have to be careful. If you're saying, well, Instagram was a competitor, and it wasn't a nascent competitor, but it was sort of a competitor in a differentiated space, then you're expanding the market. Well, some people would say, no, you don't have to do that. You can sort of in a nonlinear way say they were a unique. I think you're getting into very ad hoc, dangerous sort of use of antitrust, using the words of antitrust, but you're really sort of gerrymandering the market at that point. So long story short, definitions are important, but I think within each structure, you can work within the existing framework.
Yes, I think I agree with John. I think the US v. Microsoft framing of nascent competition is the right way to think about this. I mean, there certainly is, there are important questions about whether product A is a substitute for product B and whether they're existing or potential competitors, and I think that's something that the agencies will look at and, have traditionally looked at. But when you're dealing with, platform technologies, more often than not, these technologies have very strong feedback effects. They have their winner take all or winner take most, and the platform threat is likely to come from disruptive technologies, things that get in the way of that feedback loop. And that's really where the nascent threat was the case in the US v. Microsoft in terms of the application's barrier to entry. And if you're thinking about acquisitions, or if you're thinking about Section 2 cases and you're looking at nascent threats, it's really important to see it in the context of that feedback loop and understanding the realities of the way the market functions. That's hard to do, and I think sometimes one of the challenges we have is that we're trying to fit things into market definition boxes, like we're sort of the question almost suggests, and I think that often leads to kind of missing the mark in terms of where these issues really lie.
Diana?
Stephanie, can I just add, I mean, this is a good discussion for sure, but on the market definition issue, I think it's important to add that market definition shouldn't be the step one in the merger analysis process. So, if you go back to the merger guidelines, we've heard a lot about the guidelines. I would hope and think and expect that the agencies, given how experienced they are, would be looking to things like direct evidence first, when presented with a new acquisition involving a nascent competitor. There's been enough acquisitions, as I cited to earlier. There's water under the bridge. There should be lots of observations in terms of which deals have eliminated head-to-head competitors, which deals, where do we have natural experiments, for example, to see what happened to entry after an acquisition and even exit. So direct evidence should play a heavy role here. And then I would offer up that, the agencies, as they usually do, will have a good theory of harm going into a case before they even get to market definition, right? Whether that theory of harm is vertical in terms of classic foreclosure, or concerns over coordinated effects, or simple elimination of a small rival in a concentrated market to drive up price. So, but when we do get to market definition, which has to be gotten to unless you really have a strong case for direct evidence, we would be working very hard and carefully to translate sort of standard economic antitrust concepts over to the more complex digital markets. So, Where we have bilateral transactions in traditional markets, we have ecosystems of exchange in the digital spaces. Where we have easily identified buyers and sellers in traditional markets, we have suppliers that both sell and compete. So that's more complex. Revenue generation means value proposition on the digital market side, right? We have prices as metrics of exchange, whereas in digital markets we have eyeballs or attention or information as metrics of exchange, right? So where we have easily identified products competing with each other in horizontal plays, we might have differentiated platform offerings over on the digital market side. These are relatively easily translatable concepts, which brings us to market definition, which could include any number of relatively narrow markets, but also broader ecosystem type relevant markets that I really genuinely think can be made a case for that. So simple markets like data, cloud services, connectivity services, content and advertising, those are simply defined markets depending on the theory of harm. But antitrust, I think, has to widen the lens to think about these broader markets that might include connected services, not just in adjacent markets, but in related markets that very much are endemic to the platforms and how they create value added for their users.
Yeah, I'd just like to second what Diana said about really focusing on the theory of harm, and I think that's really even more important with tech platforms because it's not going to be so obvious where the harm might be as the markets are fluid, and looking at the competitive effects first instead of just saying, okay, this is the market as we see it. Facebook is a social network, Instagram is a photo sharing app, even though really what everybody did on Facebook was share photos. But it takes just a deeper dive into the competitive effects analysis and the theory of harm before kind of jumping to a conclusion about what the relevant product market is. The markets are fluid too. I mean, they change, they have a lot of different, like as Jonathan said earlier about it being vertical, horizontal, conglomerate, they're multifaceted.
A lot of what I would say is covered. So the only thing that I'll respond to is a comment that Jonathan raised, which is that we may need new boxes. I'd actually suggest that the nature of antitrust, both on the law side and the economic side, is that we look at older situations and try to reason by analogy, because ultimately you have to convince the finder of fact a judge. And it's about how do we make the world administrable. So what is Microsoft? Microsoft, by analogy, was Lorraine Journal, right? What is economics of platforms or economics of new economy? I think Shapiro and Varian's book, Information Rules, was brilliant because it said actually traditional economic tools can be applied in this setting that we've seen before. And oh, by the way, let's be careful for how we define markets, right? If we don't define them narrowly enough, we're going to lose. I'm going to actually go back to something that Paul Dennis raised earlier, which is the 1982 California Law Review Symposium. I'd actually suggest that people reread the work in that symposium by Don Baker and Bill Blumenthal, who made exactly that point back in the day, that actually we're going to see more enforcement in highly specialized markets. So what is old is new again, not just Steve's haircut.
Yeah, just can I comment on that? Because I think it gets to a dangerous territory, and I appreciate your remarks, Danny, and respect them greatly. But this is where I think the realities of the marketplace have to be factored and weighed above traditional models or traditional boxes, right? And so these technologies are transformative in fantastic, wonderful ways, and but they've changed industry almost forever. Right, and if you talk to people who operate in these markets, the rules of engagement have shifted in so many sophisticated ways that if you're trying to sort of figure out a model for how competition works and take the realities of these complex markets and put them into those models for how competition works, they're not going to match up. And so some of the discussion is, well, how do we modernize that? How do we look at, economics is supposed to help us understand how markets work so that we can make more informed decisions regarding antitrust enforcement. But I would say that we need to update those models because, a lot of them are a little stale for how markets actually function in today's economy. Two is the technology is really hard and detailed and sophisticated, and there needs to be greater expertise really to parse through it. And there's been discussion about a Bureau of Technology or something to start really, understanding the impact of data, understanding kind of the feedback effects and network effects, understanding which technologies are likely to impact feedback loops and network effects. And I think technological expertise is just as relevant to antitrust as economics expertise. And I wouldn't put it in the Bureau of Economics. I think the Bureau of Economics is important just and fine just where it is. But why is one sphere of expertise more important than another when it comes to antitrust, right? I don't see, one is mutually exclusive to the other.
Any further response on this question?
Plus one on not putting the Bureau of Technology under Bureau of Economics.
So I'm going to, so you have to be for merger retrospectives, and you kind of have to be for a technology group at the FTC. But I'm going to say no technology group at the FTC, Bureau of Economics or not, because I think, technology, I don't know, maybe I'm being naive, but I think it's a huge field, and every case has disparate issues, even within the realm of economics. And I can't imagine within the realm of technology. And so having a staff sort of on-hand roving to do technology on cases that involve highly technical issues in completely different technological areas, I think it makes more sense to bring in experts early in that field. So let's get a budget ready. It's not about the money. It's about getting the right person at the right time. So let's not wait last minute, of course, but let's get the right person and the expert in that field specifically. I think we'll do a lot better.
Economics is pretty broad, though, right? And so why wouldn't you have the same approach when it comes to economists and economics?
Well, IO is broad, but it's reasonably cabined within a certain area. But economics is broad, but and you can bring economic historians on. We have in the past, but they still are guided by basic IO principles of the guidelines and how we assess mergers. You learn your trade.
1 minute.
Since I had the slide on tech, I'll just throw in one thing. I think that the advantage of having something within an agency is that you create institutional memory, and I think that that's really important.
Okay, thanks. Moving on from product market now, I'd like to focus on what kinds of competitive effects and entry barriers should we be most concerned about when evaluating nascent acquisitions in digital markets, especially considering that many of these markets are considered zero price. Conversely, what kind of unique benefits and efficiencies should we credit when evaluating these acquisitions?
Thanks, Stephanie. I'll stab at this one. But I want to take my time, limited time, to really talk about one particular play. Acquisitions of nascent competitors can occur in all sorts of different plays. I mean, it can be sort of off the platform, like a Facebook, Instagram kind of thing, or it can be to the side of the platform, or it can be right on the platform. So I want to focus just briefly on a class of transactions or players that involve acquisitions where the platform is very much involved, where the platform controls critical access to data, for example, to search functionality, to distribution through payment systems, for example, to the ultimate consumer, where there might be network effects that really amp up the market and the strength of the reaction. So this specific class of transactions where you have a platform that may or may not be invested in a particular business, acquiring a nascent competitor and bringing it onto the platform, that I think deserves some very, very special attention because it's all about access. There is no entry for that type of nascent competitor because you'd have to enter at the platform level, at multiple levels. You'd have to create a whole new platform, but that's not the business model for these types of rivals. So entry is really not the issue. They are trying to get access to a platform which controls lots of functionality and is really the lifeline and the channel and the conduit to the ultimate consumer. So, that's the kind of thing for which we actually have lots of history and models and data points on conduct. I mean, I know this sounds silly, but I'm a former federal regulator, and some of my biggest projects in the earlier part of my career were developing open access rules for electric utility systems, right? Where you had a vertically integrated transmission owner and you wanted a small generator, independent generator, wanted to get on the system. They had to get access to transmission. They had to wheel their power through the system. I mean, that is a general model that antitrust and regulation has dealt with. Antitrust should deal with it by getting the antitrust laws right without having to turn to regulatory types of concepts. But the competitive effects that we worry about with that particular play are things like a platform potentially changing the rules of the game, hindering or hampering potentially interoperability, changing algorithms to make it more difficult to interoperate on the platform. I think this concept of having your own private label as a platform is, we heard this earlier in the day, really important concept. Think about shelf space in a grocery store where Safeway has its own private label. And you have a category, you have a big food manufacturer who's the category captain controlling shelf placement for that particular group of products or services. It's a similar concept, right? Looks like brand competition, but it's really not. It's an illusion of competition, especially when the platform acquires a smaller nascent competitor. So, we want to talk about data sharing, for example, the use of data, critical access, critical input. Data is a really important input, a strategic asset. To control that, to shape or control competition in those spaces. So this particular play, I think, is very important to think about. And we have some really good thinking and history and models about that are framed around the access problem and how antitrust can get to that through merger control.
Sally?
Can I ask, Diane, I'm just a little confused because, about what you're talking about, because I know, I've actually spent the last couple of years just documenting these instances where the tech platforms are kind of burying and denying access as the problem you're identifying, this access problem.
Right.
Basically denying, as I like to say, they're controlling the game, they're controlling the arena in which the game is played, and they're also playing the game themselves, right? And so they can be the platform, be playing on the platform, and then bury anyone else who also tries to play on the platform against them. Like bury their vertical rivals on the platform. Like Amazon putting its basics products at the top of the search results, or Google putting its shopping products on the top of the search results. But I haven't seen many acquisitions. Is there an example? I mean, I see this all the time, this burying, this denying of access to competitors.
Right.
But I just haven't seen any acquisitions.
Well, I think
Or
it's
I'm not thinking of
No,
them.
it's a good question, Sally. So, for example, Google's acquisition of Waze was an acquisition of a smaller rival where Google had that own capability, that own functionality itself. We could find examples in Amazon. For example, Amazon's pushing into drug distribution. That may be efficiency enhancing, given the problems we're seeing in the drug distribution markets and the PBMs, but they're, acquiring PillPack, which is going to be, a source of important input. So these types of acquisitions where the platform has their own private label, and then there's a nascent competitor, and then that nascent competitor is absorbed by the platform. The question is, well, how does that affect competition? How does it affect consumers, right? And my argument would be we need to be focusing much more on innovation theories of harm. I heard someone say here earlier that innovation theories of harm are dead. They should not be dead. They should be top of the list. How do these acquisitions potentially stifle incentives to innovate? And I'm not talking about this special goose that laid the golden egg and the VC venture capitalists or whatever. I'm talking about different types of entrepreneurial models, all of which are valid and absolutely out there. So we need to be thinking about how these acquisitions affect incentives to innovate and affect consumers in terms of prices and quality and security of their data, for example, as a quality issue, a non-price competition issue. These are all things that should be considered under a flexible, dynamic, symmetric consumer welfare standard.
Okay, would anybody else like to weigh in?
So whenever I see barriers to entry in the context of this, inevitably something about big data comes up. I feel like I'm randomly talking about big data. No one really, I was hoping to play off of it. So I just want to talk about big data a little bit for a moment. Let's just go there. So what do we mean by barriers to entry? And I think there's a problem when we label something as a barrier to entry or not, and it's just a check a box. It's a barrier to entry. And so inevitably, we think of the sort of the Bain approach to that, which then means super competitive pricing and durable monopoly power. And I think the definition has evolved, and I won't bore you with the history of the definitional evolution of barriers to entry, but I think we should really view it as how the participants in an industry use data in a market. And is this a scarce good? And are entrants really in need of this? And is it, they can't obtain it? And what is the history of the market? So for example, you look at something like search engines, something like Google, it's inevitably going to be brought up that Google and Facebook have big data, and that sort of creates and enforces their market power. And then the question is how is data being used? Is it just the existence of data, or is it part of a larger production function along with other inputs? And that those inputs are, maybe big data is a big part of it, but those other inputs are as well, including the algorithm, the quality of the employees, and the other technologies that evolve around that data. Certainly data is important, and you need it, but there's a real question of how much you need it. For example, the nascent competitive threat story. If you need big data to be competitive, why are we ever talking about nascent competitive threats? They would never be a threat. They never have big data. They're all nascent. They're small. How could they grow up to be competitive? I reject that. I think we all would reject that story. So I think we have to be consistent and reject the story that big data in of itself insulates big firms from competition. And I think history has shown, I won't go through the boring examples that everyone brings out of MySpace and Friendster, which no one uses anymore. And then, but iTunes and Spotify, a more recent example, right?
How about Tinder? No, I'm going to throw this out there. It is late in the afternoon, and I have tenure, and I can go there. So it turns out there were plenty of dating websites before. Also, disclosure, my wife and I met on a blind date thanks to the FTC. So 3 children later, we call that dynamic competition and innovation. So let me just say that there were plenty of dating websites. Again, we met the old-fashioned way. I don't
know, Danny. It sounds like you might have been on some.
No. So what I would say is the following. Fair enough. What I would say is the following. There were plenty of dating websites before that. They had tons of data. But you know what they didn't have? A great idea, which is apparently, from what I understand from my students, it's not dating as I imagine, it's dating in quotes. But this idea was a binary. Do I like them? Do I not like them? One of them is left, the other one is right swipe. I don't know which one, and I don't want to know. The point is, all of a sudden, it didn't matter that Match.com and eHarmony and all these sites had tons of data. They didn't have that breakthrough idea. Tinder did.
Stephanie, since we're all in example mode here, and it's case studies are wonderful, especially in this particular conversation, but I would offer up, to give Sally even more examples, would be Apple Shazam. So, the Europeans just took a look at Apple Shazam, and, I would submit that the Europeans took a very narrow market definition. This goes to my earlier point about not focusing the lens in the traditional narrow antitrust way, when a broader market, a market that isn't just broad to be broad for the sake of being broad, but genuinely encompasses interconnected, interlinked products and services. That can be defined as a relevant market. You need a good, powerful, clear theory of harm to back that up if you're going to go down that road, but it is entirely possible. But the Europeans took a very narrow lens on Apple Shazam. It was a theory of foreclosure that by acquiring Shazam, which is music identification paired up with digital music procurement, that they would have access to data that would allow Apple to target customers, to steer them towards getting the tune, actually purchasing the tune on iTunes, and away from rival Spotify, for example. Well, lo and behold, Spotify apparently never complained about this. And so there's been this real robust debate about why that didn't happen, why there was no complaining from Spotify. But That's an example of, sort of a narrow lens around a relevant market, a well-crafted theory of harm, vertical foreclosure, can't complain about that. But how could that lens have been broadened in a way to capture more than just data markets, but also capture sort of the end user experience and choice and under a consumer welfare standard?
Okay. Okay, I'm going to move on now, unless anybody has anything else to say on this topic.
Very, very quick. So as we look at each particular case, we should also look to see what is sort of the prior history of the company. So sometimes when companies make acquisitions, they leave the targets as separate subsidiaries, and they don't really mess with them. And that, I think, looks very different than a full integration. And sometimes full integration works, and sometimes it doesn't work. And these are all things that agencies should consider.
Okay. So moving on, a key issue for the agencies when thinking about these cases is determining when a nascent technology is likely to develop into a significant competitive threat, such that we might have concerns if it were acquired by an established incumbent platform. What factors should the agencies consider when predicting the competitive significance of nascent technology firms? How reliable are these factors? And how does this issue affect the agency's ability to challenge nascent acquisitions?
Yeah, I can start. I mean, I guess I raised some of this in my opening remarks, and I do think there are signs or things that we can, signposts that we can use to help understand these issues a little bit better, but I do think this is an area where we need better research, we need better rules of the road so that we can help spot problems sooner and with greater effect. And I think that's part of my point where we've fallen down because we're so defensive as a community that sometimes we forget to look inward, and it's why I think this process and these hearings are so important. But a few things to look at. One, is it a winner-take-all or winner-take-most market? Does it exhibit strong feedback effects? Are the nascent competitors relevant to that feedback loop? Is the market share really durable and high, in which case you would have a heightened concern? Does it require entry at multiple levels and multiple stages in order to be successful? Does a platform exhibit conflicts of interest, and will the transaction change the extent to which it has the incentive and ability to act on that conflict of interest? Those are some of the signposts that I think we should be using. Also, as I mentioned in the opening remarks, and I think this goes back to the comments from Chairman Potofsky, we do need to be more sensitive in certain markets that involve speech, that involve marketplace of ideas, that involve information that's vital to our functioning democracy. And those markets are really important, just as courts, including the Supreme Court, have given them heightened levels of scrutiny and importance, so too should the antitrust laws.
Sally?
Oh, go ahead.
There you go. So some similar points that I wanted to make, but just kind of some questions to be exploring. How will the acquisition help a tech platform either obtain monopoly power or maintain its existing monopoly power? And could the platform get access to new types of data that will fortify its existing monopoly power? So it's not just all data, big data, it's about unique data. And I think that, there's qualitative aspects of data that we need to be considering. How could the acquisition help a tech platform leverage its monopoly power into a new market? How could the acquisition exclude competition through vertical integration or tight vertical integration or foreclosure of access to APIs? And maybe that's a type of merger condition that could be used more often, is to go requiring that requiring APIs to be made available to competitors. And also, as I mentioned before, what's the strategic reason the tech platform is buying the target?
So when I look at this, my bottom line is we're not going to say anything new that the agencies don't do already. I mean, the bottom line is evidence, evidence, and evidence. I sound like Jan Brady, Marcia. Dated reference, dated. Nobody's talking about the Brady Bunch anymore. But
Old theory of harm.
just being in the agency for 18 years and going through this, and for any antitrust counsel who's been on the receiving end of a FTC second request or inquiry into these sort of areas in potential competition theories, they will attest that every stone is looked at. You know, I find it incredible that there's this sort of this notion that there's some new areas that the FTC need to look at in various things. I mean, just the amount of documents, amount of data that we get, the amount of analysis that we pursue, the experts that we hire, it's just a very thorough process, and I just like to defend the agencies in that respect, and I think they're getting it right.
Let me, and that was Scott Sher there clapping for the record. Hi, Scott. You know, I think that I agree. Listen, I have great respect for the agencies and the work that they do, and having been on the receiving end of many second requests, they are indeed very painful and invasive, and the agencies put a lot of effort into turning over stones. So this is not in any way an indictment of the work of the, you know, tremendous professionals. But where I do think we sometimes end up is we still end up trying to put all the facts that we're gathering into little boxes, right? And I've even had, you know, folks at the agency say that, well, here are boxes, and how do we fit these facts and these data into those boxes? I mean, we're talking about on the previous panel, Susan Creighton, who I think the world of, both professionally and personally. She was talking about a rule of per se legality so long as it's a product improvement, right? That doesn't sound like turning over stones and boxes and figuring out effects. It sounds like saying, okay, there's an outcome-oriented rule here. And so I think on one hand, we do look at a lot of information. We do look at a lot of data. On the other hand, you know, sometimes we don't always know what to do with it in the context of the way these markets work. And you know, we maybe can do better in terms of understanding the realities of the way these marketplaces work so that we can appreciate the significance of the data and so that we can appreciate the significance of the massive amount of information that the agencies are considering as part of a transaction or a conduct investigation.
Stephanie, can I just provide yet another mundane, non-digital market example to illustrate a point? And that's actually the Maytag-Whirlpool merger. Which is now, you know, an old merger. But that merger was allowed by the DOJ. It created an enormous market share for Whirlpool in white goods, something close to like 80 or 90%. But it was allowed through because of the essentially the nascent competition from the Asian white goods producers, so LG, Samsung, and Haier. Okay? So DOJ let that merger through on the roll of the dice that the nascent Asian competitors were going to get into the market and discipline the market. And you know, there's a fact pattern there that would be very useful to port over to the digital market side. How were the Asians going to be competitive? Well, they were going to have to get access to distribution in the United States. Getting access to retail distribution is really, really tough. There's an analogy to that when you interoperate on a platform. And you're acquired by a platform. You have to get access to shelf space. You pay slotting fees. You have to develop brand recognition and brand loyalty. So all these factors go to supporting the notion or a set of parameters for determining whether a nascent competitor is enough of a threat. And it needs to be thought out. I don't have all the answers, but it's a tough question. I think, as we've heard all day here. What I hope we don't end up doing is ginning up a bunch of bright line tests for what is determinative of what's a nascent competitor and their competitive impact, potential impact, or influence.
Okay, thank you. We have about a minute and a half left, and I'm going to give the final word to Danny on this topic.
Thanks. I'll be very fast because I don't know how to speak not fast. So this is really hard to do, and if it were really easy, we should form our own VC fund right after this session. And the reason I say that is, right, the VCs have better information than the agencies ever will, right? They have control rights. They are in the company every day. They are firing the CEO often before we get to some kind of exit, more often than not. That's why Andreessen Horowitz found a gap in the market to have a different model. Okay, so what does this come down to? If we're a VC, we look at team. This is something that Will talked about. We look at market. That's something that Bill talked about last session. We looked at scalability. I think that's something everyone's talked about. And it turns out it's so hard. Even with all of that, most of the returns on venture capital come from the top 5% of all VCs. Now, of that 5% of all VCs, more than half of the companies in their given portfolio for any particular fund have a return on investment of 0. So they can't even get it right, because if it was that easy and they're seeing the best companies and they can't make the good bets, it's not easy for the rest of us. So I'm going to go back to something that the first part of what John talked about. Agencies work very hard to get this right. Absolutely. Now, the second part of should we be thinking about broader categories? We should be thinking about whatever will give us better information to make better decisions. And I think we can all agree to that part. And it's all about getting that information to, in a very, very tough situation, can we get it right? And a lot of times, it's not clear that the people who make a ton of money on this can get it right. So I'd say let's keep expectations at a realistic level.
Okay, thank you. I think we're done. Yep. Okay, so everyone, please join me in thanking our panel for an excellent discussion. And if everyone in the audience